note that today is her 14th year moderating the Supreme Court Institute's term preview, which means he needs little introduction in front of this audience. So I will just briefly note that Professor Bornstein served as both an assistant and counselor to the Solicitor General of the United States, arguing 38 cases before the court. His appearance as chief of SEI report panels, however, numbers in the hundreds. Professor Bornstein.
Thank you. I'll begin our program as is customary with an introduction to the term. If you look at the term before this last one, there was a lot of evidence that the court had become a 6-3 conservative court that was moving very quickly and very far in a rightward direction. The top 4 cases were Dobbs, Bruin, West Virginia, and Kennedy. And in each, the court divided 6-3, and in each, it moved the law dramatically in a rightward direction. This past term, though, looked different. It's true that if you look at the top 3 most high-profile cases, Harvard, 303 Creative, and Biden versus Nebraska, you see the same 6-3 split, moving the law in a decidedly rightward direction. But if you look at the next set of cases, which were probably just as important, you see a different picture. In Moore versus Harper, the court voted 6-2 to reject the independent state legislature theory, a right side theory if there ever was one. In Halen versus Brackeen, the court voted 7-2 to reject a right side assault on Congress's power over Indian affairs. And in Allen versus Millian, the court voted 5-4 to reject a right side effort to gut Section 2 of the Voting Rights Act. Those results and others are evidence of a 3-3-3 court, with the center block of conservatives consisting of the Chief Justice, Justice Kavanaugh, and Justice Barrett, who side with the 3 other conservatives in many cases, and sometimes, though, with the left side of the court and others. The question for this term is whether last term voting behavior will hold or whether the court will snap back to a 6-3 court. My prediction is we will see at least one more term of a 3-3-3 court. 2 factors inform my prediction. First, we still see some right side advocates who seem to think because we won Dobbs, we can win anything. That leads them to advocate positions that at least some of the center block of conservatives are not going to be able to stomach. That wouldn't matter, except for the fact that the Fifth Circuit is ready to adopt the politically most conservative position on almost any issue, no matter how implausible and no matter how much defiling of precedent it takes. Some of the Fifth Circuit's decisions that will be reviewed this term may well be affirmed. Not every one of them was delivered from Crazy Town, but it would be shocking if at least some of those decisions are not reversed. We have a terrific panel here today to discuss some of the upcoming cases in alphabetical order. They are Lisa Blatt from Williams & Connolly, David Cole from the ACLU and Georgetown Law, Ramon Martinez from Latham & Watkins, and Hash Mupan from Jones Day. They'll cover 5 topics: guns, the administrative state, social media, civil rights, and pharma bankruptcy. Each will present one principal case in that area and briefly touch on at least one secondary case. After each subject matter presentation, other panelists will be invited to weigh in with their thoughts. After a discussion of one of the areas is completed, I will invite press questions on that set of cases. If panelists want to weigh in on my introduction, please feel free to do so. We'll start with Hash on guns.
So I'm going to start today with United States versus Rahimi, which is a Second Amendment challenge to a federal law that prohibits the possession of firearms by certain individuals who are subject to specific domestic violence restraining orders. And this is the first Second Amendment case to reach the Supreme Court since the seminal decision in Bruin a couple terms ago. So the case is pretty important, both because of the public safety implications of the particular law at issue, but also because of the general fleshing out of the Bruin standard that's likely to follow. So, as I'm sure you all know, in Bruin, the court did a lot of things, but of most relevance here, the court adopted essentially a history and tradition approach to the Second Amendment. They said that where a gun restriction is covered by this plain text of the Second Amendment, i.e., it infringes the right of the people to keep or bear arms, it's presumptively unconstitutional, and it's the burden on the government to show that that regulation is consistent with the nation's historical traditions of gun regulation. That said, the court included several caveats that are going to be pretty important in sort of thinking through Rahimi. One is that the court made clear that sort of this historical analysis is flexible. The court said it's, when you're looking at historical analogies, we're not going to have either a regulatory straitjacket or a regulatory blank check. So they're not going to require a perfect analog, but they're also not going to let the government point to either sort of outlier examples or, strained analogies to uphold a regulation. And they said that when they're thinking through analogies, the question is going to be, is it a comparable burden and is it comparably justified? The second point that the court made in Bruin that's going to be quite relevant here is sort of throughout the opinion, they repeated again and again and again that the Second Amendment is about protecting law-abiding ordinary citizens, law-abiding responsible citizens. And Chief Justice Roberts and Justice Kavanaugh had a concurrence that specifically emphasized and reiterated that point, emphasizing language from the earlier Heller opinion, saying that the court wasn't calling into question presumptively lawful regulatory measures like the long-standing bans on possession of firearms by felons and the mentally ill. So with that background, let me turn a little bit to the facts of Rahimi. So if the government could have picked a case to be the first post-Bruin case, I think they would have picked this case and this statute. So first, the statute is a fairly narrow statute that I think most people would think is fairly common sense. It bans the possession of firearms by individuals who are subject to a specific type of domestic violence restraining order, and in particular, the restraining order has to have either a specific finding that the individual is likely to pose a threat to the safety of an intimate partner, or it has to expressly prohibit the individual from using force or threatening force against an intimate partner. And Mr. Rahimi might be the poster child for why laws like these exist. He assaulted his girlfriend using a gun in part of it. After he was then subjected to the restraining order, he violated the restraining order. He used a gun against another girlfriend, and he was engaged in multiple shootings, including several road rage type incidents. So he was then unsurprisingly prosecuted for possessing a firearm despite being subject to that restraining order. And the Fifth Circuit, applying Bruin's history and tradition approach, said that the law was facially unconstitutional. So I think both sides' sort of lead arguments are not going to be sufficient to carry the day, and I think it's going to end up turning pretty heavily on how the court approaches this historical tradition. So on the one hand, the government's lead point is to just emphasize pretty heavily the language that I talked about earlier from Bruin about law-abiding, responsible, ordinary citizens, and they've found a lot of historical evidence of similar language talking about the Second Amendment, peaceable citizens, honest citizens, that sort of general language, and then relying on the sort of common sense impression that people who are subject to domestic violence restraining orders are not that. And that's going to go a long way to getting the government where they need to be, but it's at too high a level of generality. I think the court's going to be concerned about relying on such vague phrases to uphold a restriction without doing a more granular analysis of who are the types of people who historically have been disarmed for being irresponsible in that way, and is this sort of restriction sort of comparable to what is historically done? Sort of conversely, the Fifth Circuit in Rahimi emphasized pretty heavily that there isn't a historical tradition of disarming people in this precise category, right? So there isn't a historical tradition of saying that an individual poses a specific threat to another person and there's been a civil order to that effect, and based on just that, we're going to disarm the person. And they've got sort of the flip problem, which is that's true, but I think the court's going to be reluctant to rely on just that without an analysis of, well, are there analogous types of threats that have led to people being disarmed? Because if there are, the court's likely going to conclude that the historical absence with respect to domestic violence doesn't really tell you very much about the framing understanding of the Second Amendment. It tells you about the framing understanding of domestic violence, which is fairly archaic and not shared anymore by basically anyone. So it's really going to end up turning on the historical tradition and which analogies the court finds relevant. I won't sort of belabor the sort of back and forth about the various analogs here. Suffice it to say that there's a lot of, the government points to an example, the other side tries to say it's disanalogous for various reasons. What I will say is it's a curious case because, at least from my perspective, I think that the government has the weaker of the historical analogies and the government is certain to win the case. And so the interesting thing is going to be watching to figure out how sort of the moderate bloc of the conservatives try to thread that needle of coming up with a reason why, under the history and tradition approach, the government wins, even though the government's historical analogies aren't all that great. And so the reason I sort of think that is, both Chief Justice Roberts and Justice Kavanaugh went out of their way in Bruin to emphasize that this historical approach wasn't going to take out sort of common restrictions like these. Justice Barrett, when she was on the Seventh Circuit, wrote a dissent in a case involving felon disarmament, where she adopted a test that looks to whether you've committed a category of dangerous activity or there's individual evidence of dangerousness, both of which seem to be met here. And even Justice Alito, I think, is this is sort of crime adjacent and will have lots of implications for felon bans, which I'm fairly confident he thinks are valid. So I think all of them are going to want to uphold this, but I think all of them are also going to be struggling with the fact that because the analogies aren't great, they have to figure out a way to write it so that they're not sort of openly relying on very high level generality comparisons. Because they're going to be worried that if they say, oh, look, responsible people, that's it, then like that sort of gives a roadmap to jurisdictions to sort of pass new restrictions based on similarly vague phrasing. And so I think one of the things to be watching for an argument and to expect at the decision is to see how they try to sort of thread the needle there. And then I think the other interesting thing to watch for is to see how the liberal justices react to that. Like, there's no question they're going to vote to uphold the statute, but the question in my mind is, are they going to sort of give the conservatives cover of saying, yeah, that historical analysis is right, these are close enough analogies, the law should be upheld, or are they going to say, no, these analogies don't really work, and that sort of just shows that the historical approach is misguided. So that'll be an interesting thing to watch to see how they handle that strategically. So that's basically all I have to say on Rahimi. The other gun case that I'll just briefly mention, there's a set of cases that involve the question of whether the federal ban on machine guns applies to so-called bump stocks. There are a set of cases involving this. The lead one is probably a case called Garland versus Cargill, also out of the Fifth Circuit. Court is very, very likely to grant cert. There's a circuit split. Both sides agree the court should grant it, and so they almost certainly will. So the definition of the federal definition of machine guns essentially says that it covers guns that can automatically fire more than one shot based on a single function of the trigger. And what bump stocks do is they essentially harness the recoil of the gun such that when the shooter pulls the trigger once, the gun sort of moves back and forth and keeps bumping against their finger. So the shooter doesn't pull the trigger more than one time, but the trigger ends up getting depressed multiple times. And so the question essentially textually reduces to, does a single function of the trigger mean, can the government say that means a single pull of their finger that causes the trigger to depress multiple times? And as a functional matter, the question is, does a gun that, for all intents and purposes, looks like it's functioning like an automatic weapon, will they say, well, that's true, but textually, the trigger is actually pressing multiple times. I won't say too much more about the merits because I worked on that case when I was at DOJ. I will say that one other interesting thing to watch for, if Chevron survives Loper Bright, is there are a bunch of interesting Chevron-related questions in this case, because this came up in the posture of ATF promulgating a regulation banning bump stocks after the Las Vegas shooting. And despite having passed a regulation, ATF didn't invoke Chevron deference. Some of the courts of appeals, nevertheless, upheld it under Chevron deference, and so there can be questions of, is Chevron waivable? How does Chevron apply in this context where it's a regulation that has both civil and criminal applications? And so there are a lot of very interesting Chevron questions in the case that might arise, again, if Chevron survives Loper Bright.
Thanks, Josh. Anybody else on that set of cases?
Yeah, I just have a couple things. So I think by one count that I read, there's been 31 successful gun challenges in the wake of Bruin, which is incredible, just showing how much of an impact. And I thought the biggest one was not bump stock, but this one arises out of 922 G8 is a domestic order one, but G3 applies to prohibits possession of a weapon by anyone addicted to a controlled substance or a user. And I think that's before the 10th Circuit in the Western District of Oklahoma struck it, but it's also the Hunter Biden statute. There's another one, G6. You can't own a weapon if you were dishonorably discharged from the Army. G9, if you were convicted of a misdemeanor domestic violence. There's also, it's unlawful to sell a shotgun to anyone under 18 or any firearm under 21. And when I try to put that through a history and tradition, my sort of head explodes. One of the things, in reading in the government's brief, they must have cited that responsible, law-abiding citizen thing, what felt like 50 times, is I just kept thinking about all the hypos the court is going to ask them. Does that include people convicted of a DWI? What about tax evasion? What about polluters? Those don't sound like responsible, law-abiding citizens to me, as opposed to somebody who's been found to have misused a gun. And one of the things I was thinking about, because I don't think in terms of the case law, I think in terms of what makes sense, is do we think of the Second Amendment as a right or as a privilege? If you think of it as a right, I'm not really sure I care about any of that stuff, whether you're a polluter or law-abiding, or do you think it's a privilege, something you have to earn? And how do you think about public safety? What happens in all these cases, I happen to co-teach with Paul Clement, so I'm used to hearing a lot about the views on the other side, is most of us who are for gun regulation think it's very important for public safety, but we hit the alternative argument, well, if you care about public safety, everyone should be armed. And it's, that's a policy debate, but it definitely informs a lot of the thinking. And one of the things that I think about when I think about in history and tradition is, why do I really care about history and tradition? Guns were in schools, were they in places of worship, public buildings, 13 and 16-year-olds? Do I really have to go back to, the Rifleman or Little House on the Prairie to figure this out? Because I think guns were everywhere. And so I'm just not sure how the court's ever going to get themselves out of this mess. And I do think lower courts are starting to think about it. And you can watch them dress it up by history and tradition, but what I really think is going to animate it is how they conceive of the Second Amendment versus whether it's a privilege or a right.
Others?
The ACLU pretty rarely files in support of a prosecution and against the defendant in the Supreme Court, but in this case, we did. But we urge the court to take a much narrower approach than the United States takes. I think the United States approach is, as has been suggested, really extraordinarily broad, and I think it's driven not by their need to win this case, but their need to defend the host of broader gun possession laws, some of which Lisa referred to. This one, I think, is relatively easy to defend on the ground that there is historical support for the notion that people who are individually adjudged to be dangerous in some sort of proceeding could be denied the right to carry a weapon. And that's all you need to decide to reverse the Fifth Circuit and uphold the application of this law. The notion that any right, and I don't think it's the Bill of Rights, it's not the Bill of Privileges, so the Second Amendment is a right. The notion that any right is limited to law-abiding, responsible citizens seems to me really odd. I mean, there's no, the first, if you don't have to be law-abiding, responsible, or a citizen to have First Amendment rights, Fourth Amendment rights, Fifth Amendment rights, Sixth Amendment rights. They apply to all people. They apply whether you are have been convicted of multiple crimes or are accused of one or none, and they apply whether you're responsible or irresponsible. So that seems a very extraordinary broad assertion, and I think it's driven by the fact that the gun possession laws are themselves extraordinarily broad. I mean, the notion that, which everyone seems to think is just fine, that a felon should for the rest of their life not be able to have a gun, applying to things like tax felonies. What possible justification is there for keeping someone who committed some tax fraud from having a gun for the rest of his life? So, and the ACLU is concerned about the use of gun possession laws to lock people up for very long periods of time, to increase mass incarceration. There's evidence that it's used in a disproportionate way against people of color. And so we're concerned about the breadth of these laws, but in this case, we think this law is tailored, narrow, serves a very important interest, and is supported by history.
Oh, one other thing in terms of how the court can get out of it. The court here in the Fifth Circuit talked a lot about it. The problem with the statute is that it applies, as Hash said, when there's been a credible finding, so that's an individualized finding of dangerousness. But the other basis for the protective order can just be on its face, it prohibits you from violence, and so that is incredibly nuts because you don't have to have a finding of dangerous. Here, the individual had both the justifications for the domestic order. There was both a finding of individualized dangerousness and it on its face restricted him from engaging in violence. And this is a facial challenge. And I could see the court just saying it's not facially invalid and it's not invalid as applied to him. And they can just not resolve any of the issues about what happens if you're just subject to an order. And one thing that Judge Ho talks about is a lot of people enter into domestic restraining orders just out of consent. So a lot of times I'll just be sexist here, for the woman to get the man to enter it, they'll just consent to a mutual one. And so even though there's no basis for the woman finding that she's dangerous, she'll subject herself to the same restraining order. And that's bad according to Judge Ho because she needs to be able to use weapons.
I think my fellow panelists have covered this well. I think the only thing I'll add is I do think that the fact that there are two different ways to trigger the gun prohibition under the statute is potentially going to yield some insight into how the court is going to be thinking about this issue generally. And I think, as Lisa was just saying, the fact that one of the two ways that you can lose your right to have a gun is if there's a specific finding of dangerousness as to you that's kind of been adjudicated. That seems much more defensible as a ground to take away someone's Second Amendment rights. And to the extent that the court focuses on that and maybe decides not to address the broader question of the other looser ground, I think suggests that the way they might think about these other statutes when they come up is really about, focused in very narrowly on the dangerousness question, and to what extent is it fair to think that some of these other restrictions on gun ownership are motivated by a proxy for dangerousness. And the felon question, I think in some cases depends on the kind of felony that you've committed. You're maybe more likely to be dangerous for some crimes than for tax crimes. So it'll be interesting to see how they decide it.
Okay, press questions? Oh, yeah, go. So
So what do you think this case is going to mean for the court's approach of analysis by analogy for the Second Amendment? Is this going to be something that they might say, okay, Bruin was the start of this, we might apply it to other amendments, sort of other constitutional right analysis? What do you think Rahimi is going to mean for that?
did everybody get the question?
Yeah, look, I think that for a lot of other constitutional provisions, there's a lot of doctrine that's already built up around it, right? Like, what was different about the Second Amendment was because the individual right was first recognized in Heller fairly recently, they had basically an open playing field, and given an open playing field, they were able to adopt a history and tradition approach. there's just so much doctrine built up over most of the other Bill of Rights provisions that it would be pretty disruptive to do that. Insofar as there are open questions, open areas, I could see history and tradition playing more and more of a role, but I don't really see them saying, for example, like all First Amendment laws going out the window and we're going to know the history and tradition approach to that.
I do think that the kind of new wave of originalism, especially in a newer area where the originalist doctrine is being applied, like in the Second Amendment, I think it poses opportunities but also challenges to originalists. And I think that this case is a kind of early example of like sort of working out how is this going to work in practice. And since Bruin, we've seen a lot of commentary and law review articles and some judges being sort of throwing up their hands. This is impossible. We can't do this. And I think I don't think that's necessarily true, but I do think it poses a fair question and challenge to justices and judges who are originalists to kind of explain and show how this is going to work and how it's going to be a workable system of adjudication to be applied. And I think there are tools that they're going to have to work with, and I sort of suspect that maybe because this case is one that's a better case for the government, this is one where they can show how the method works and how it's not some crazy thing, and how they can offer some guidance to lower court judges and show that it's not a kind of out of left field academic theory, but something that judges can actually apply.
I would just say to Harsh's point about, most of the amendments have a lot of doctrine that you have to overturn if you were going to apply an originalist approach. If you look at the 2 terms ago, originalism seemed to be on the rise. You had Bruin, you had Dobbs, you had originalist gestures in the religion cases. Last term, it went to sleep. I mean, there was almost no originalist decisions, and I think that's because in most areas the law is very well settled, and you'd have to be pretty radical to adopt an originalist approach. The other thing I'll say is that I think Rahimi specifically illustrates one of the real problems with originalism, which is because they're going to want to uphold the statute, and there is no precise historical analog, and so they're going to have to raise the level of generality. A lot of the discussion we've had is how high will they raise that level of generality, but that's one of the things about originalism is that it doesn't dictate what level of generality the court adopts, and so it doesn't actually constrain decision makers in the way that its proponents often claim that it does.
In the takings case last term, the county that wanted to take away this grandmother's house kept relying on originalism, and I think Justice Barrett at one point said, we didn't have cars back then or something like that. It was like she wasn't having any of it. They were going to take away this woman's house. That's all there was to it.
Okay, so Rahman on the administrative state.
Sure. So over the past few years, it's become very clear that the Supreme Court, and especially the conservative justices, have been laser focused on what they see as the excesses of the administrative state and how it's gone beyond the original constitutional plan and structure. And so we've seen a steady diet of cases in which the court has been sort of walking back aspects of sort of agencies run amok in various ways. There's been a dialing back of deference doctrines. There's been the emergence of a new major questions doctrine. There have been a series of challenges to ensure sort of proper presidential oversight and control of independent agencies. And sort of every term now we see a handful of cases in this sort of general line. The overall, I think, conservative objective here has been a good faith effort to sort of take a look at where the administrative state is and compare it to the original Constitution and kind of change the trend and push things back to the original constitutional lines. I think on the other side, the folks who are concerned about this are worried about that, the fact that in terms of policy, if you walk back the administrative state as it exists now and as it's sort of accumulated across the 20th century and into the 21st century, you're going to make it a lot harder to achieve progressive policy outcomes and policies with respect to things like environmental regulation, public health regulation, and consumer protection. And so that's sort of the debate and the context in which this term the court is going to address. For now, just 3 cases. We'll see if there are more coming down the pike later that sort of implicate this sort of constellation of issues. The 3 cases, just to put them on the table, I'm going to focus on the first one. Loper Bright Enterprises versus Raimondo. The court is going to consider whether to overturn the Chevron deference doctrine. In CFPB versus Community Financial Services Association, the court is going to consider a challenge to the somewhat unique funding structure for the CFPB, the Consumer Financial Protection Bureau, which doesn't depend on annual appropriations from Congress and instead essentially allows the CFPB to take money that has been obtained in through fees and other ways from the Fed's sort of budget, almost essentially de facto, maybe without limitation, although it has been Congress has given the CFPB permission to do this, subject to a very high cap. And then the third case, Starchese versus SEC, the court's going to consider a number of issues, including whether the Seventh Amendment right to trial by jury prevents agencies or Congress from setting up agencies and giving them the power to adjudicate securities violations of the securities laws and assess civil fines and penalties in ALJ proceedings, as opposed to going to an Article III court where you'd have a jury. So I'm going to focus on Loper, which is a big Chevron case, administrative law case, but it's also a fish case. So just on the facts very quickly, the facts don't really matter all that much. But the case involves a federal statute which essentially gives the National Marine Fisheries Service the authority to promulgate rules that require observers to go on fishing vessels to collect data that is needed for the government's conservation efforts. And so the statute requires or allows the agency to require these observers, but it's silent as to who's going to pick up the tab, who's going to pay for the observers. And so the Fisheries Service adopted a rule that would require certain vessels in certain places to pay the costs of these observers themselves. So imposing the costs of the observers on the sort of regulated entities or on the private fishing entities. And it turns out that the cost can be quite substantial. The briefs say that the cost can amount to as much as 20% of the sort of value of the fish that are caught. And so it's a pretty substantial imposition of these costs. The fishing entities sort of challenged this regulation, said it was unauthorized by the statute. There's no right for the agency to impose these costs on us. And the lower courts essentially said, well, the statute's silent here. We can kind of see it both ways. It's sort of ambiguous. It's not clear what Congress would have wanted here. And under the Chevron doctrine, we think the agency's approach of having the regulated entities pick up the tab for the observers, we think that's reasonable. So we're going to apply Chevron deference, and therefore the agency wins. And so the Supreme Court granted cert and is going to consider whether the longstanding Chevron doctrine is still valid or whether it should be overturned. And the petitioners make five different points that I'll just quickly summarize. One, they say Chevron, although it is a longstanding preference from the 80s, it should get limited stare decisis effect under the usual calculus of when to overturn precedent, because it's not a rule about a substantive question of what a statute means or what the Constitution means, but instead it's a procedural rule, a methodological rule about how courts should interpret statutes generally. And so it tries to get around the normal heavy stare decisis effect with that argument. It then says Chevron is egregiously wrong for a series of reasons that have been well aired in a lot of law review articles and speeches and a lot of public discussion over the last 10 years, essentially that arguing that Chevron violates the Constitution because it takes away the court's power to say what the law is and gives that power essentially to the agency, because the agency can adopt an interpretation of law that is reasonable even if the court doesn't think it's the right or the best interpretation. The court still has to defer to the agency. It also takes power away from Congress because Congress is essentially able to kind of just write a statute that's not totally clear, and the agency gets to be the one making the ultimate sort of legislative or policy type determination. And then the petitioners say there's also a due process problem with all this because Chevron is usually invoked in litigation against the government, and the government's a party to the litigation, and it seems a little unfair for the court to ask the party and defer to the party's view of what the law is when there's a legal dispute between the party and the other side. The petitioners also say that Chevron violates the Administrative Procedure Act, which in their view requires courts to decide legal issues de novo. Petitioners go on to say that it should be overruled, not just because it's egregiously wrong, but also because it has bad consequences. It's hard to apply in practice, which is maybe why they say the Supreme Court hasn't applied it in about 8 years or so. They say it encourages overly aggressive executive branch interpretations of the law, and that it subjects citizens to regulatory whiplash, where Chevron, combined with the Brand X case, essentially allows different administrations to come in and change what the law means by having their agencies adopt diametrically opposing interpretations as to the previous agency, which then subjects citizens who had thought that the regime was settled to then, be subject to a new set of legal requirements, even though Congress hasn't done anything to actually change the law. And for that reason, the petitioners say there are no strong reliance interests that are engendered by Chevron. Petitioners also have a backup argument that if you're not going to overturn Chevron, at least you should narrow it, and you should say it shouldn't apply to places where there's just a regulatory silence in the statute. And so it should be cases of true ambiguity, but not silence, which I think is a tough line to draw, but that's their backup point. The government hasn't yet filed its brief in the case, but we are likely to see a full-throated defense of agencies.
It did file.
It did file?
Yeah, I think it was yesterday.
On Friday. Well, I haven't
Yes,
seen it yet.
yeah.
My panelists are ahead of me and can tell me what it says. I predict, though, it says that Chevron should not be overruled. And so the government, consistent with the arguments it made in the Kaiser case involving very similar issues of agency deference to agency interpretations of regulations, is going to say there's no constitutional problem here, that Congress can validly delegate to agencies the authority to interpret their own statutes, and courts are absolutely doing their usual Article 3 job when they're just assessing whether that delegation is made, and they should apply their independent judgment to that question, and then defer only if the statute's ambiguous. The government is probably going to point to the fact that in the Kaiser case and under a host of other decisions, the court has made clear that the step one inquiry is a very robust inquiry, and therefore it's going to be the rare case in which there's a genuine ambiguity that is going to lead to deference, so that should give people comfort that this isn't going to be just a blank check to agencies. And they will make a host of other arguments, including policy arguments, about why it's important to be able to defer and have a government that allows expert agencies to make these judgment calls, especially on questions that don't trigger the emerging major questions doctrine, smaller questions where really agency expertise is valuable and important. So that's basically the case. I'll just give a couple of observations here and then open it up. I guess maybe I'll say a quick word about the other cases, but first, I think the precedent question is actually very interesting. We've seen a lot of debate about the court and whether it's too willing to overturn precedent in recent years. I think that criticism is something that maybe that the middle block of three justices is attuned to. And I think the petitioners have done a nice job of maybe offering the court a sort of distinction between this kind of precedent and other kinds of precedents that maybe would allow that wing of the court to kind of say, well, we're talking about a different kind of precedent. The normal rules don't quite apply, and so this is different. I also think another precedent-related question that's going to be interesting and tricky is if Chevron is overturned, as most people think it may well be, what happens to the cases that have been decided under Chevron deference in the past? And the petitioners don't say a lot about that in their brief. They sort of have a cagey sentence or two, which seems to imply that the holdings of those cases, the interpretations of those cases are still presumptively good, whatever that means. But I think that's an interesting question that will come out of the case. With respect to the outcome, I think if you just read the trend of the case law in this area generally, I think that there's good reasons to think that the challengers to the regulation here have a lot of wind at their back coming to this court, especially in light of the changing composition of the court over the last few years and the replacement of Justice Ginsburg with Justice Barrett. In the Kaiser case, which involved very similar issues, the court upheld, refused to overturn Kaiser deference, but it was a 5-4 vote, and Justice Ginsburg was in the majority in that case. I think that if you look at the middle block of justices here, Justice Kavanaugh seems likely to overturn Chevron. If you look at his articles that he's written in the past and a lot of his decisions and opinions that he's signed on to, I think he is very skeptical of Chevron deference, at least the way it's been sort of traditionally conceived. The Chief Justice, I think, in the Kaiser case, was unwilling to overturn Kaiser deference, and I think for reasons he's laid out there and also in some other decisions of his, he is probably a harder vote for the challengers to get. I think the Chief seems to think that if it's the right kind of issue that's not a major question, that it is fair to think that Congress did in fact intend to delegate to agencies some authority to issue interpretations that are reasonable, even if a court might disagree. And I think that the chief may well sort of follow that line of cases and come out the other way. I do think that there are some practical problems with how Chevron has been applied and how it's been sort of maybe de facto overruled by the Supreme Court in the sense that the court isn't applying it. I think there's some practical considerations that may lead the court to think that the doctrine just isn't workable anymore, and that might be a reason cutting in favor of just getting rid of it. But if you look at his prior decisions in this area, it seems like he might be willing to uphold Chevron and just continue to narrow it. So I think the kind of key vote is probably Justice Barrett's, because she would be the fifth vote. With respect to Justice Barrett, she's said less publicly about the Chevron issue. I think it's notable that last term she signed up to a concurrence by Justice Gorsuch, where he was quoting his prior opinion in the Kaiser case, his dissent in the Kaiser case, and basically took the position, and Justice Barrett seemed to agree with it, that the Administrative Procedure Act requires de novo review by courts of legal questions, which could be a sign that she's skeptical of Chevron and willing to go all the way on Chevron. I also think her interesting opinion last year in the student loan case sort of laid out and gave us a window into her thinking on questions of textual interpretation, and seemed pretty firmly in the camp that the court's job is really to figure out the best interpretation of the statute and apply that. And that case didn't address Chevron, but if you take a lot of the logic and reasoning in that case and transfer it over here, I think it would lead one to think that she might be skeptical as well. So I will stop there. And Irv, I don't know if I ran over it. I'm happy to say a word or two.
Why don't you say a word or two?
Yeah, I think
just set
the
up questions if people want them.
So on the other two cases, I think these are cases that I will not use Irv's terminology, but Irv might say fall into the sort of Fifth Circuit going too far type of category of cases. And so it's interesting. They're both cases in which the government has sought cert. And on both issues, I think the arguments that the challengers to the agency have are harder than under Chevron. But they both raise important and sort of substantial challenges. The CFPB case is really dealing with a one-of-a-kind statute and a one-of-a-kind agency that was deliberately designed to insulate it from political control in a way that I think a lot of the conservative justices that are skeptical of the administrative state are going to find very compelling. These arguments about this sort of effort to really make the CFPB so independent and outside of the normal system of government. I think those arguments are going to resonate. I think the question is going to be whether the particular funding mechanism here, it goes so far as to violate the Constitution because it doesn't satisfy the requirements of the appropriations clause. I think one challenge to that argument is that Congress did in fact authorize this expenditure and did in fact impose a cap, although it's a very super high cap, and one that as a practical matter probably doesn't make a lot of difference. I think another challenge is that there are other agencies, including the Federal Reserve, that are kind of outside the normal appropriations process, and I think it's unlikely that the court is going to want to mess with the Fed. So it'll be interesting to see how the court deals with that. It's not to say that the challengers couldn't win, but I do think that is a harder case for the anti-agency side than the Chevron case. And then finally on Turkesi, I think it raises really fundamental questions about the right to a jury trial and what is it that the SEC is doing when it's adjudicating securities fraud cases. I do think it would be fairly transformational if the court were to rule that these ALJ proceedings are not allowed, because that's something that has been sort of understood to be allowed for a while. But I don't think it would be crazy for the court to go in that direction. I don't have a strong view how they're going to rule. So I'll leave it at that.
Thanks. Others on any of the cases?
Go ahead. No.
Yeah, so a couple of reactions on the Chevron issue, right? So I think that Ramon's right that Justice Barrett's probably the key vote. I think one interesting thing is, she obviously clerked for Justice Scalia. Justice Scalia was actually, for most of his career at least, a well-known proponent of Chevron deference, and it'll be interesting to see how she thinks about it. I think the government actually did a very good job of trying to frame the defense of Chevron in similar ways to Justice Scalia's defense of it. And so, one basic pitch they've made is to say, this isn't a question about whether you're going to have a delegation at all. It's a question of who you're going to delegate it to. Are you going to delegate in a situation where you've got a statute that's genuinely ambiguous, right? You've done all the traditional tools of interpretation, and there are reasonable arguments either way. Who's going to make that call? Is it going to be the executive branch, or is it going to be a court? And, part of Justice Scalia's pitch was, well, it should be the executive branch because they're more accountable, right? I think a lot of the current conservative angst about Chevron is related to the fact that they don't think agencies are more politically accountable. They view them as this sort of fourth branch, headless, unaccountable even to the president. And so if that's the inquiry, is it you want to go to some agency who's unaccountable to anyone or a court? Well, at least it's a court, right? But that's why I think a lot of these admin law issues are related, right? If the court at the same time is trying to make agencies more accountable to the president, right, through all the cases like the removal cases and other areas like that, then the sort of Scalia-esque conservative view for Chevron has a lot more going for it. Because really, when you've got these esoteric, detailed things that courts frankly don't have any clue about, why would you have them do it rather than a genuinely politically accountable actor? So I think they've made a pretty hard pitch on that, and we'll see how much it resonates. The other sort of related point is, after the major questions doctrine, it's sort of ironic that Chevron's biggest practical effect is making it easier to deregulate. And the reason why is if you've got a major pro-regulatory action, it's more likely to not get Chevron deference because of the major question doctrine, right? The court's going to say, oh, that's a big deal. You need to have a clear statement. Even under Chevron deference, you lose. But the flip isn't true. If you have a major deregulatory action, that's never going to implicate the major questions doctrine because it's the agency not doing anything. So the Chevron right now in the real world practically has more effect in safeguarding deregulatory actions. And I don't know if that was if that connection gets made, and the government pushed it a little bit, but not too much, because they don't want to actually play up the major question doctrine, which they don't like. But if the conservatives think about it that way, they might realize that Chevron actually isn't something they should dislike as much as something they do.
Others?
Yeah, I will just say, first of all, that was amazing, Ramon, because he was exactly right what the government argued. The only thing I would say is, sorry, but I found
research skills that are problem.
the government's brief was tone deaf. It said that Chevron reversing it would render a convulsive shock to the legal system, and the whole brief read like, well, we've always had Jim Crow laws, and so it's been working real well, and who really cares, and it'd be really upset a lot of people if we reverse it. It was just completely clueless to the fact that even the government hasn't been citing it or relying on it for the last 5 to 8 years, and the court hasn't been doing it. So I found the government's brief, I'm not sure it's going to attract, I think it may irritate some people.
Anyone else? Press? Yep.
Do you expect during arguments to hear any concern about what impact overturning Chevron would have on lower court judges? Because it seems like some of them may be worried that they're going to have to play, expert when in terms of making regulation. So I'm just wondering how much that might come up.
I suspect that the Supreme Court is not going to care that much, honestly. I mean, I think that the logic of a conservative majority overturning Chevron is going to be like, yeah, this is what courts are supposed to do, interpret the law. And sometimes they're hard legal questions, but you got to listen to the parties, you got to give respectful consideration to agencies and take their positions into account, but you don't have to, you're not supposed to defer to them. So I suspect that to the extent that comes up, I don't think the court's going to care about
Yeah, a lot of them, well, at least two of them, sat on the DC Circuit, and so they know that these cases are all coming out of the DC Circuit, and the DC Circuit is incredibly dependent on Chevron. So I do think it might come up from the Chief and Justice Kavanaugh, but a lot of the other courts of appeals have not been applying Chevron. So I think this is a DC Circuit specific issue.
Well, and the other thing, one of the points the government mentions in their brief is that Chevron reduces the sort of ideological valence, like the relevance of ideological composition on panels, right? When you have statutory interpretation questions without Chevron, the partisan balance of the panel is much more of a predictor of how the court rules than under Chevron, right? And so I think the government's going to play that up too. I'm like Ramon, I'm not sure it's going to really matter because I think a lot of them are going to have the instinct. It's your job to decide the case, but I do think lower court effects will be significant.
Anything else? Yeah.
So you guys talked a bit about this with regard to local right, but I think this one is more focused on the other two. When we think about these cases, like separation of powers cases, we tend to think about the relationship between like Congress and the executive or the executive within itself. I'm wondering what those kind of cases say about judicial power and, the courts kind of are they trying to rein in some of that for themselves, or does it say nothing at all about judicial power?
I mean, I think the deference cases say are in a very significant part about the judicial power and how the justices see the judicial role, and that they need to be, the buck needs to stop with them when it comes to saying what the law is. I think on some of the other issues, it's more the courts sort of being assertive in policing the boundaries between, the other branches and ensuring that there isn't like some new fourth branch of government that kind of like takes on a life of its own. It's not so much about their own authority. I don't think they see it that way, at least the folks who are writing these decisions. It's more about they're playing traffic cop as opposed to protecting their own authority. But I don't know.
I think Jarkizi a little bit, right? So one of the issues in Jarkizi is whether these penalty proceedings should be done in-house in agencies or in courts, and at least some of the folks who think they should be done in courts view that as like, I think Chief Justice Roberts used the phrase like it's their judicial birthright to like adjudicate these cases. So I think there is a little bit of that going on that issue of you shouldn't be able to take these sort of common law type disputes and shunt them over into an administrative process.
I also think, though, on the question of judicial power, back when the conservatives were interested in judicial restraint, that was an argument for Chevron deference, and you had many conservatives defending Chevron deference in those terms. Why should we be making these sorts of decisions, including sort of solid conservative judges like Larry Silberman. So it's shifted now, and I guess they're more confident that they'll get the right results from courts than from agencies. But it's not obvious, sort of in the abstract, it seems to me not obvious. If your goal is deregulation, which is I think what the conservative agenda is about, it's not obvious that very conservative courts or captured agencies are going to be more, amenable to deregulatory ends.
And, it doesn't have a little bit to do about your prediction about who's going to be president of the United States over time. I mean, if you think it's always going to be Democrats, you're foolish, but you might think that. And if you do, though, you'd think, oh, great, Chevron. But if you, and on the other hand, if you're deregulatory, the opposite. So I do think a lot of this, the way the worm has turned, has a lot to do with Chevron grew up at a time when Republicans were president. And, the left side kind of came around to it, I think, on the DC circuit, in part because there was so much political tension on that court that it was a way of avoiding all that political tension, and they could really resolve a lot of cases as a court and get agreement pretty easily by deferring to the agency and save their battles for other kinds of cases. I do think that as things have turned out, that has over time there's been more Democratic precedents, and they've been doing things that seem extreme to the right side of the court. And if you apply Chevron in the old-fashioned way, at least, you'd have to uphold it. And so that gives birth in part to the major questions doctrine, but it also makes you skeptical about Chevron overall. And so I'll leave it at that.
I do think one other just comment. I mean, I do think that the effect of Chevron, as we've seen it with major regulatory initiatives over the last 10 years, it does create this weird world where the law is like constantly changing on significant issues back and forth depending on who wins. And that seems like a weird state of events that doesn't really track the way the Constitution seems to think that law should work. And I think a related effect of that is that it makes it harder to, there's a point the petitioners make in their brief, I think it's right, is that it becomes easy for Congress just to kind of like not legislate, because they can basically, if they have the White House, they can use the pen and the phone and not use the legislative process. And if they don't have the White House, they can just hope that they're going to win the next election. And there's just less pressure on them to legislate, because the executive branch can kind of rescue them and then get upheld by the courts. And it just seems like that's kind of a perversion of the way the system is supposed to work.
Okay, we're on to the next. Lisa, social media.
So this is the opposite of the nerdy stuff. This is fun and it's very accessible because most people know what social media is and use the internet. So the court has already 2 social media cases on, but I think it'll end up having 3 total at least. But these are the cases of O'Connor, Ratcliffe versus Garnier, and I don't know how to pronounce that, Link versus Freed. So these cases are scheduled for argument on October 31st. It's Halloween. I don't know if anyone's going to dress up. But the questions presented are whether public officials who use social media to communicate about their jobs are acting as public officials. And is that social media activity state action? If it is, then their activity and their speech online is subject to the First Amendment, including prohibitions on speaker and viewpoint discrimination, such that if they block you on Twitter or block a critical or negative post, that would be blatant viewpoint and speaker-based discrimination. So here the facts are, we have, and Hosh can correct me if I'm wrong on any of the facts, but we have one case involves the O'Connor case, school board trustees using Facebook and Twitter. They blocked some parents, and a city manager, Freed, used Facebook to talk about the city's COVID policy, and he blocked, or she blocked, a city resident. So the arguments are pretty, I think, well drawn, and I think maybe it's not ACLU. I think it's, but the public officials, the United States and the Sixth Circuit have a pretty bright line rule that it's state action and you're acting in, an official capacity only if you're using your account to perform a specific government duty or under the authority of your office. And here the problem for the other side is that I think in both of the cases, these officials, these are private accounts where they're discussing, their families and posting pictures, but they own and operate their own accounts. No state funds or public employees are involved. Like I said, they're using the accounts to discuss both their private and job-related information, and significantly, they both started their accounts before they became public officials. And then they have this argument, their policy argument is basically, if you make them state actors, they're going to be chilled from talking about their jobs online. So the parties who were blocked and the Ninth Circuit who went the other way have a much more, for me, kind of a harder test to understand, which is why I think they'll ultimately not going to prevail. As long as the officials are using their social media account to invoke the pretense of government authority, would the public think they're engaged in official communications because they're sort of coming from a government employee and they're talking about their job as if they're a public employee? It looks like a public pronouncement. Just in terms of the way the law should work, I think Hosh's side has a much cleaner line. It's easier to understand, and I think it probably will prevail. My question for, I'm giving him all the moot court questions, is what about the president? Recall that the former president blocked 41 Twitter followers. It was held he was acting in a state capacity. It went to the Second Circuit. The challengers won. The government sought cert. Somehow it mooted out, I think, because of the election. But this was from his @real Donald Trump thing, and the court had held it as a public forum. It seemed right to me. I just don't know how the president making policy, and I just think there's going to have to be a way where people are going to be able to say that is state action. And then I also sort of have questions about why wouldn't every public official just evade the First Amendment by using their private account? What if the official goes on his private Facebook page and says, can I get public comments? I'm thinking about closing schools. I'm reinstating masks. What do my citizens think? What if I am a Republican and I only let Republicans on my page? What if I say I'm only going to let white people on my page? Those are the kind of hard questions I'd be asking just to torture Hosh. Oh, okay, let me discuss 2 other cases. So these cases definitely overlap with 2 cases that I'm sure you all are aware of. Sort of this net choice case coming out of both the Fifth Circuit and the 11th Circuit involving the Texas and Florida laws that impose very draconian things on social media about disclosing how they engage in content moderation. And the issue is the courts are divided under whether these very large internet and social media companies are basically common carriers in public forum. The government has told the court to take it. It's obviously a very important issue. I do think the government's going to take it. I think based on the way the 303 Creative case came out, it's all but, it seems to be overwhelmingly likely that the internet companies will win because they have their own First Amendment right to decide how they want to organize their content and who they want to, how they want to fashion, just like the New York Times has its own rights. The other case that's coming through and the stay, it's happening right now, is the Fifth Circuit. I think this comes out of, it's definitely coming, I don't know if it came from Alabama, it's another Fifth Circuit special, has basically enjoined Missouri. That's right, because it's Missouri who filed it. So enjoined CDC, FBI, the Surgeon General, and the White House from certain types of communications with the social media companies. And the trigger words are, you can't coerce or significantly encourage these platforms to moderate speech on their platforms. Justice Alito entered a stay till Friday that expires. The government sought an emergency relief. The response is due today by Missouri and the 5 people who had their content either taken down or banned. The case law does say that the government involves state action when you force a private person to do something if you're coercing them or significantly encouraging them. The problem with those standards is I don't know what significantly encouraging means. So what the Fifth Circuit said, and this all arises out of, I guess, the COVID communications and maybe the election claims. There were a lot of statements by the White House, both in public and in private communications. There were statements that we all heard from CDC, from Surgeon General, and who knows what the FBI was doing, but just communicating with, you've got this thing, you've got this elevated thing on your platform. You're misleading the public about the safety of vaccines. And what the Fifth Circuit said is your tone and demeanor was really harsh. So, and they talked about referencing adverse consequences, like, you do know we can propose legislation. And so is that really coercion? And then the definition of meaningful, significantly encouraging is just, are you exercising meaningful control? Are you involved in their decision making? These are very loose standards. The government cried, Armageddon in their petition and said, you've just stopped, 40 millions and millions of public employees from doing their jobs, which is looking at what's available online. And this injunction is way too broad. So we'll see what happens on Friday.
Okay, others on any of this?
So we did file in the cases about public officials blocking people from their ostensibly private accounts in support of those who were blocked, not in support of the public officials. And I think it's an interesting state action question. I think one way of thinking about it is that most state action cases involve private individuals or private entities that someone is saying should be treated as the state and therefore subject to constitutional constraints. And I think presumptively a private individual, a private entity is not the state. And so there's a fairly high bar on when you're going to treat a private actor's conduct as state action. That's not these cases. These are cases about whether, when public officials act, should they be subject to the Constitution. And I think there the presumption is actually the opposite. A public official should generally be subject to the Constitution. Now, it's true public officials are not always acting in their official capacity. When they're at home, having dinner, they're not necessarily exercising their government authority, and so the Constitution doesn't necessarily apply to their dinner table conversation. But I do think a different standard should apply, and the standard that we've proposed it comes from a number of Supreme Court cases that have addressed this question of when public officials or people clothed with official authority should be treated as acting as acting for the state when they are engaged in state, official state business, of course, and the challengers don't really, Hosh doesn't dispute that. but also when a reasonable observer would understand them to be using their state authority. And that is, Lisa says that's a tough standard to apply. Agreed. But the court has applied it in the past. So there have been a couple of cases where private security guards who were deputized with state authority, but were not exercising their state authority, were working in their private capacity for private employers. One of them is, at a fairground or something, and they, kick people out of the fairground based on race, or they interrogate someone who's suspected of doing something illegal. And the court says it doesn't matter that they are not exercising their state authority. What matters is whether a reasonable observer would understand them to be exercising their state authority. And if that's the case, then they should be constrained by the Constitution. So that is an approach the court has taken in the past. I would hope that it would take that here, because otherwise, as Lisa suggests, it's a very easy way for public officials to evade their responsibility. The other thing is, on the other side of this is, of course, public officials should have the ability to speak in their private capacity, but it's very easy to do that. And the Justice Department, has long said, if you're working for the government, you can have a private, website or social media page. Just talk only about private matters on that. And you do government business on that. You do government business on the government website. You do and on private business on the private website. So there's no real burden on the government official if they're held accountable in situations where they're using their website to, to sort of conduct their business and give at least the appearance that they are acting as a public official. And then on the last case that Lisa talked about, the
Murphy.
What's it called?
Murphy versus Missouri.
Yeah, Murphy versus Missouri. This is a hard question, right? The government obviously has the right to speak, and it obviously has the right to reach out to social media companies and say, look, there's something on your website that's really problematic. It's terrorist, or it's whatever. It's misleading people that the polls are going to be open when they're not, and so they're going to suppress votes. Whatever it is, obviously they have the authority to do that. That's government speech. It's also true that they can't coerce private actors to take action on their behalf. And Bantam Books is a case from many years ago in which the court said when you can't write a letter to a bookseller and threaten them with prosecution to encourage them to not sell protected pornography, essentially. And so, how do you draw the line between coercion and government speech? Very difficult, very important, I think. I tend to agree with Lisa that the facts of this case, it's not clear where there's actual coercion, and that significant encouragement is a very slippery standard.
Yeah, the only thing I'll say, which is why I love teaching with David, David shows his adherence to doctrine, and I just don't think doctrine works ever, especially with social media. And it doesn't, yeah, sure, security guard pointing a gun, I don't care whatever standard, you're gonna get that result. But to me, this is, when it comes to the internet, case law almost never drives it. They'll dress it up with however they want based on the result. I think they're gonna have to leave open the president, somehow.
I'll avoid answering any hypos as much as I want to, but the one thing I will say is, I think it's important to recognize that public officials, not only do they have their own First Amendment rights, the right to speak in the personal capacity, they have that right with respect to government affairs, right? A public official has the right to speak in his personal capacity about what the government is doing, to engage with his common citizens, to talk about the matters of the day. And that's especially true because a lot of these people are elected officials. They have to run for office. And you can't run for office without talking to your constituents about government work. And so I think that's part of when you're trying to figure out how to draw these lines and whether they're exercising state authority or carrying out their duties. trying to figure out how you distinguish between a public official talking to the public as part of his job, as opposed to as a private person, including a private person running for re-election, is, I think, one of the important issues to look for.
Anyone else? Okay, we're on to the press. Yep.
Lisa, can you say more about how you think the 303 decision informs what they might do in that choice?
Sure. I mean, 303, it's definitely a case that was framed in terms of religion and gay rights, but it was an incredibly impactful First Amendment case, incredibly impactful about coercive speech. And if you require businesses to either associate or engage in First Amendment protected activity that they don't like, that's a heinous violation of the First Amendment. And if you set up a blog, Lisa Blatt's blog, the notion that the government could tell me what to put on my blog is so offensive to the First Amendment. And so unless you believe that YouTube or Facebook is somehow the government, it's just a blatant First Amendment violation to tell Facebook what they want on their homepage, how they need to, the internet is a big thing. A website has billions and billions and billions and billions of data. They've got to organize it somehow. And for the government to tell any private person how to organize a website, it's just after 303, I don't know how the Texas and Florida people even have an argument. My view. I'm biased.
Yeah.
Lisa, there are also those provisions of the Florida law that the 11th Circuit upheld and are the subject of a cross petition, and the government makes a distinction about general disclosure.
Right.
Yeah. Would you agree with that distinction, or are you
So
saying the whole law?
disclosure is supposed to be the same standard as compelled speech. I don't think as a practical matter it is. It always just depends on how burdensome the disclosure is. So I think, the 11th Circuit upheld some disclosures. That's just basic transparency. I mean, I can't talk about the specifics because of my clients, but it depends. I mean, there's disclosure generally is subject to the same, but I think as a practical matter, it's treated differently.
In the Murphy case, whatever the government did or didn't do right, is an injunction the proper form of relief? Isn't that a prior restraint?
Well, so there's all kinds of arguments that the government's making about standing. I think they should have, and part of the analysis to get to standing was because we can enjoin you, you have standing. And so I would expect the government to fight on that. But he's my First Amendment
I don't know
scholar.
if it's a prior restraint, because it's not, I mean, the government speech is not protected by the First Amendment, is it? The government has the authority to engage in government speech, and it doesn't violate the First Amendment by engaging in government speech. So, and all that it has restrained is government speech.
Yeah, they could definitely enjoin you for retaliating. Like if the government said, we will throw you in jail, I'm sure they could get an injunction saying, don't tell people you will throw them in jail. But generally, I guess what I'm saying is where your equity brain is going is correct. The injunction is weird. It's just something about it applying to, I don't even know how the government employees would be able to follow this injunction, given some of the wordings, how vague it is.
It's mostly the vagueness. The vagueness is the big problem with it, right? Because yes, everyone agrees the test is coercion. Significant encouragement is a little weird. I tend to think of it as the flip side of coercion, right? You can't threaten a penalty, you can't offer a benefit. That's like the easiest way of understanding what that is. I don't know if the case law really maps that,
No.
but otherwise it's totally unworkable. But when you phrase it that way, at that level of generality, it doesn't tell anyone on the ground what to do.
Right, don't have meaningful involvement with anyone's decision.
And especially in a situation where, one might have been surprised to think that the Fifth Circuit thinks that, like, the government can coerce, like, huge companies by, veiled language, right? Like, there's probably a mountain of Fifth Circuit case law involving, like, police officers interrogating people where they don't say that's coercive. So, if you're actually an officer trying to sort of comply with this injunction,
That's amazing.
it'll be pretty tough.
In all these cases, I don't understand what the state has to do with any of these cases. In other words, if the CDC is giving Facebook a hard time on what they're, What does Missouri have to do with it?
So that's funny, because Missouri says their citizens have a right to listen, and therefore they have standing. And I think the government makes fun of that in their state papers. The blocked officials have a much stronger case of standing because they were whether blocked or demoted. But I think it's Missouri and one other state. It's 2 states. I forgot the other
I think
state.
it's Louisiana. I think that's
Yeah. But this is just what you've been seeing in all these cases. It happened with ICWA, student loans. The states always join with private parties. It's kind of bootstrapping on standing. The court's all over the map on state standing. The states lost a bunch. They won a bunch last term. What the states are doing in here is unclear to me. But their listeners have a right to hear a speech that the election was stolen, is their view.
Usually, I find this whole lawsuit kind of peculiar because it's not the ban of books kind of lawsuit because the companies are not suing. It's the people the companies are blocking that are suing. And normally, you think when somebody's been turned into a state actor, you sue them for violating your rights, in which case you would think you would be suing the internet companies who are now state actors for violating your rights. And of course, it seems to me you'd have no claim whatsoever because the internet companies, if the court comes out the way Lisa says they're going to come out, can throw you off if they want to. And so I don't see how, and if you imagine them as government actors, unless it's a public forum of some kind, the government can throw you off of its website if it wants to. And so, anyway, I just throw out those thoughts.
I think some of these comments sort of play to the fact that we're dealing with a doctrine that's been built up in a certain type, dealing with a certain type of free speech marketplace that's just evolved radically with the advent of the internet and social media. And so you have a world now where companies, not the government, but companies sort of are hosting the public square and have the ability to influence it, and the state actor rules don't apply to them. But then the government is trying to kind of leverage that by sort of achieving what would otherwise be thought of as censorship through other means. And so it raises, I think, really substantial, challenging questions. And I think it's right that maybe the existing doctrine doesn't fully neatly map onto this new scenario. But it does seem like this is like an area where, it's reasonable for courts to like sort of think about these new problems in different ways and think about fundamental First Amendment questions like what are we trying to achieve with the First Amendment, and isn't there kind of a problem if we're letting the government sort of throw its weight around in a way that we wouldn't let them do if they were controlling the public square directly? And I think that's like the fundamental problem that this case gets at, and also the net choice set of cases get at, is like this new media speech environment, and how do we think about the companies in relation to the speakers and to the government? So I think it's maybe the most interesting area that the court's going to have to deal with this year and in subsequent years.
That's why I don't understand the state's role in the other cases. If Texas and Florida can tell YouTube what to do, and California's probably not going to have the same view. How could the social media companies operate if each state gets to say, hey, we'd like more of this and less of that?
Well, they already have to do that with respect to other governments.
Yeah, so the only issue, I think, and we should probably let other people speak to this, is the First Amendment issue, but there are other issues about those state laws. Like, there are other defenses to them that raise all the issues you're raising, but what is teed up is by the Fifth Circuit and the 11th Circuit is purely the First Amendment challenge.
Yeah, and I think Roman's exactly right. I mean, if you think about the First Amendment, the court has applied a different standard to the print media than to the broadcast media, at least initially. It applied yet a different standard to cable, with the understanding that it was a different kind of speech environment. And so there are arguments that this is a different kind of, there are definitely arguments that this is a different kind of speech environment and requires a rethinking of
we should have won ACLU versus Reno.
Well, but I was going to say in ACLU versus Reno, the court said no. The First Amendment applies in the same way online as offline. So, and I'll just say I think the cases that apply a different standard to the broadcast media have been widely criticized. The cable cases are not that significant. I think it's hard to sort of distinguish between the New York Times, which, the government, of course the government can call the New York Times and say, hey, look at, what you're publishing is false, you shouldn't be publishing it. And the New York Times will make its decision. And Facebook or Google, they're private entities make it with editorial decision-making responsibility. They exercise that responsibility through content moderation. They couldn't exist without exercising that responsibility. So although I think Roman is right that this raises really important questions about this new world, I think it's very hard to sort of come up with a different way of applying the First
In the
Amendment.
Section 230 case, I did represent Google, but also in the net choice case, there's definitely a massive reliance on parades, newspapers, broadcast media, TV. The one thing that'll be interesting, and it came up somewhat in the 230, by the time all this is briefed about the internet, everything's happening with AI. So the court's going to be it's always going to be a couple years behind. But we're going to have all these issues again with AI.
Can I just ask whether any of the changes in Twitter or Facebook in terms of moderating political content atmospherically, does that have any effect?
Well, if you're talking to me, I think everything is atmosphere and policy driven. So yes. If you're talking to David and anyone else up here, probably not.
I just had one.
Did that answer your question?
I had one follow-up. Lisa, you made a comment about kind of that the court's been all over the map when it comes to standing. And I was wondering, other than that Missouri social media case, are there any others that stand up this term where the state has questionable standing?
Yeah, there is. Well, there's a bunch. I mean, the Purdue case we're going to talk about, that's the trustee standing. Where else did we read just about standing?
Well, there's other standing cases. There's a tester standing.
Tester
case.
standing's coming out.
And then there's a serious standing question in the
Miffy.
in the Miffy.
Yeah, sorry, abortion.
Purcell case. But those are not.
They're not
that's
state standing.
These aren't
that's
state
private
standings, but
individual
standing seems to be all over the court's docket. It was last term kind of brewing, and I think it's going to bubble. It's going to bubble.
What do you mean?
Burst, but with Miffy and these cases, the social media cases too.
And will they have to provide some sort of will we get some sort of clear
No, they're always going to leave standing case by case, so that way they can manipulate.
So I do think there's a pretty high correlation between what the court thinks on the merits and what the court thinks on standing. And so if it, for example, thinks the government should win, probably on the merits, as it did in the challenge to the mandate, on whether it was going to take down the whole ACA, Affordable Care Act. Probably not, but it was much easier to get a consensus behind saying the states don't have standing. So too in the last term's US v. Texas case, when probably everybody thought, there's nobody has any business telling the executive, the 5 people at least thought nobody has any business telling the executive branch on the merits who it should arrest and not. And so much easier, rather than saying that, to say there's no standing.
Well, Independence
and on
State
the other
Legislature
hand,
too, they did the
and
same
just
thing.
on the other hand, if you take the Missouri versus Nebraska case, when the majority was dead sure that the Biden administration had overstepped, no surprise that they're going to find standing in that kind of case. So I really do think there's a very high correlation between, and always has been, between a justice's view on standing.
Except for abortion, because I do think it doesn't really matter. If standing can work to everyone's advantage in that case, because they don't have to have another abortion case if they can knock it out on standing. If I were them, I wouldn't want another abortion case, but we'll see.
So we're on to civil rights.
So I'm going to talk about 2 redistricting cases, one on the merits, one on the shadow docket. Alexander versus South Carolina is a racial gerrymandering case on the merits, which will be argued October 11th. And Allen versus Milligan is coming back up from Allen versus Milligan last term at the remedial stage, and that's on the shadow docket on the state's request for a stay. For disclosure, the ACLU is counsel in both of these challenges. So Alexander, as I said, is a racial gerrymandering case. Since Shaw versus Reno, the court has said that the states may not sort voters by race. They may not use race as a sorting mechanism, even if their ultimate goal is something else, like it usually is, partisan advantage. And in this case, that's exactly what the three-judge court unanimously found happened in South Carolina. After the 2020 census, South Carolina had to adjust its map, as states generally do, because of population movements to get equal population. And basically, the only problem it faced was that Congressional District 1 had 85,000 too many voters, and Congressional District 6, the neighboring district, had 85,000 too few voters. So how do you solve that problem? You move 85,000 voters from CD1 to CD6, and you now have equal population. That is not what the state did. Instead, the state moved over 190,000 voters. It moved 50,000 into the overpopulated CD1, and then moved 140,000 different voters out of CD1 into CD6. And yet, after all of this movement, unnecessary movement, they ended up with exactly the same black voter age population, which is referred to as BVAP by voting rights lawyers, before and after, 17%, which turns out to be kind of the at least from their perspective, the point at which you can have a reliable Republican district in CD1. If you go too much higher, there's risk that it might go Democratic. So they moved all these folks unnecessarily. They did it really. They brought into the district 3 heavily Republican districts, but in doing that, they also increased the black voter age population in the new CD1. And so for every one black voter that they brought in through bringing in the heavily Republican districts, they moved out one from Charleston County, and ultimately moved 30,000 black voters out of Charleston County, moved 11 of the 12 voter districts in Charleston County that had over 1,000 voters, and then denied that they considered race at all. Said on the stand, never looked at race, even though race was on the computer screen as I was doing the map. This is the map maker. Even though the map maker, months after having drawn the map, could recall with precision the racial composition of each of the voting districts that he had moved around, he said, I never considered race at all. The court found that incredible. One of the judges said, we have a saying here in South Carolina, when you see a turtle on a fence post, you know someone put it there. And so they found that this was a form of racial gerrymandering. The last piece of evidence that supported that was 2 experts who, for our side, who looked at the moves from CD1 to CD6 and used statistical regression analysis to try to determine whether race or partisan identity better predicted which districts got moved, and it turns out race was a better predictor than partisan identity for who was moved. South Carolina's appeal is basically a factual appeal. They basically argue, no, we didn't move people based on race, we moved people based on politics, but at the appellate level, that's a clear error standard. As long as the lower court's decision is plausible, the court is supposed to affirm it. They do make some broader legal challenges. I think they're all pretty weak, but then I'm biased. Sort of maybe one of the most interesting is an argument that the plaintiffs should have had to put in an alternative map to show that you could get to a Republican tilt without the 17% black voter age population, to try to disentangle whether it was race or politics that moved. But I think, the response is we did better than that. The map, it doesn't involve any kind of regression analysis or anything. We brought in 2 experts who actually looked at all of the factors that might affect how the moves were made, and found that race was a better predictor than politics. And they put in no expert to the contrary, and were unable in any way to undermine the credibility of those experts. At the end of the day, the prohibition on racial gerrymandering is of a piece with the notion of colorblindness that 6 members of the court feel very strongly about, as we saw last term. The fact that that you're using race to further Republican partisan advantage shouldn't change that principled opposition to the use of race. Then I'll talk briefly about Allen versus Milligan. That's on the shadow docket, as I said. You will remember last term the court upheld a victory under the Voting Rights Act in Alabama, where we demonstrated that under Section 2 of the Voting Rights Act, black Alabama voters were sufficiently numerous and compact that Alabama could have had 2 black majority districts. Alabamans are about 28% of the population. They were they had one of 7 districts in which they could elect candidates of their choice. That's 14%. If they had 2 of 7, it would be 28%. And while proportionality is not the test, we were able to demonstrate that you could have come up with a reasonably configured map that had an additional black majority district, and that racially polarized voting exists in Alabama, and that whites vote cohesively. And so unless you do that, black voters are not going to have an equal opportunity to elect candidates of their choice. And so the remedy was, to Alabama, affirmed by the Supreme Court, the remedy was come up with a map that provides a second black opportunity district, either one in which African Americans are a majority, or where they have a sufficiently sizable percentage of the population that they have a chance at electing a representative of their choice. The court, the lower court, in this case a 3-judge court, which included 2 Trump judges, ruled unanimously for us the first time around. The Supreme Court affirmed. They gave the legislature a substantial amount of time to come up with a remedy. The legislature made no effort to come up with a second opportunity district. Instead, they drew a new map, had their lawyer, the Solicitor General for Alabama, write up quote-unquote findings that were kind of reverse engineered and retrofitted to explain precisely the lines that were drawn, and then said, well, we're starting afresh here. There's a new map. You have to bring a whole new challenge and demonstrate that this new map violates the Voting Rights Act, and you have to do so using our jerry-rigged for gerrymandered findings drafted by our lawyer to justify the new map. The court, the 3-judge court below, had none of that. It said no, if the violation was that you failed to create a second opportunity district for African American voters, the remedy is you create a second opportunity district, and you admit that you didn't create a second opportunity district. That should be the end of the case. But then they went on and said, because that would have been a very short opinion, they wrote a 200-page opinion. They went on to say, well, okay, let's take your argument that we should treat this as a brand new case, and we will ask whether the plaintiffs have demonstrated that Section 2 is violated by this map. And they said, yes. They then applied Section 2 to the new map, and they said, yes, you have violated Section 2 with this map. And the only real issue that Alabama raised was whether we had demonstrated that African Americans were sufficiently numerous and compact to allow for the creation of a reasonably configured second district. That's the first part of the Jingles test, which guides the application of Section 2 of the Voting Rights Act. We had shown that before. And the fact that they drew a new map doesn't change where Black Alabamians live and whether they are sufficiently numerous and compact to allow for the creation of a reasonably configured district. Reasonably configured means generally consistent with the kinds of traditional districting principles of compactness and contiguity and the like. The Alabama seems to be playing, is obviously playing to Justice Kavanaugh. When the court decided Allen versus Milligan, it was 5-4. Justice Kavanaugh wrote a concurrence in which he had one line in which he said, at some point, the Voting Rights Act, Section 2 of the Voting Rights Act, which in some instances requires race-conscious map drawing in order to ensure that minority voters have an equal opportunity to elect candidates of their choice. At some point, that may become unconstitutional. It may have been constitutional in 1982 when it was enacted, but at some point it may become unconstitutional, but Alabama hasn't raised that here. And Alabama seems to think that they are setting this up for Justice Kavanaugh to say, well, I upheld it last time around, but now that you've raised this claim that there are constitutional problems with a race-conscious remedy, I'll go the other way. I think that's unlikely. I think this case has the feel of too many civil rights cases of yore in which the states take action to harm African American folks. The case goes up to the Supreme Court. The Supreme Court says, you've harmed African American folks, fix the problem, and the states resist. And they often use, quote unquote, race neutral means to resist, but it really feels like a resistance to a Supreme Court opinion. And so, my sense is that even if Justice Kavanaugh at some point wants to revisit this question, I don't think he's going to see this as the vehicle. It's up on, as I say, it's up on a stay request. We filed our opposition yesterday, so we should get a decision relatively quickly.
Others on this one?
Just a couple of reactions. I should be careful. My firm actually represents the state in the South Carolina case, so I'm not going to say too much, but I will just make two observations.
That's why I didn't say anything either.
So one is, David made the point that the population disparity was something like 80,000, but a lot more moved in and out. But that's always true because you want to move people in and out to get to the right population number, but you also want to comply with traditional district principles like maintaining county lines and all those sort of things. And so the way you do it is by, they're like sub-districts. And so in order to not break sub-district lines, you move more people out, move more people in, and net you end up at the right spot. And so the question really is, in these sort of cases, is there a reason to think that they were doing it for racial reasons rather than non-racial reasons, where they move people in and out? And what's weird in this case is, the Supreme Court has now held that partisan gerrymandering is not a problem under the federal constitution. And the state has openly said this was a partisan gerrymander. And so the question becomes, well, we could have moved Democrats openly and loudly. Why would the state have, instead of moving Democrats, have moved blacks as an indirect proxy to get to Democrats? And so I think that's the sort of essential question in the case. And you could, we'll debate about whether it's a factual question or a legal question. The standard you apply to figure out whether you're moving Democrats as such or moving blacks as an indirect proxy for Democrats. But that, I think, is really the heart of the case.
Yeah, and the facts on that are that they had the racial data. It was right up there on the screen. They also did have some political data, but it was only data from the 2020 presidential election. And presidential elections are frequently outliers in which people do crossover voting, and so they're not generally very good data to predict long-term voting patterns. Whereas black in South Carolina turns out to be a pretty good basis. So that's the I think, the reason why they relied on race rather than politics.
Other press? Yeah.
To reveal underbelly of my ignorance, can you try one more time, in layman's terms, to explain why Alabama here thinks it can get Kavanaugh? And secondly, if the court looks at this very quickly and says, you're playing games, can you explain what it would mean, nuts and bolts, if the court summarily affirmed?
So I think right now they're asking for a stay. The court, if it rules for us, will just deny the stay, which will mean that the remedial process will continue to go forward because there's no stay at this point. The remedial process is that now that the legislature has shown that it has no interest in providing a remedy, the court has appointed a special master, and both sides get to propose maps, and the special master will adopt a map. So that's what will happen if the court agrees with us. I think that the idea, Kavanaugh's idea seems to be kind of along the lines of Shelby County, that, even though if Shelby County, at one point it made sense to impose these special rules on southern states that had a history of racial discrimination, but surely we've moved beyond that. And so it no longer is justified. And I think, at some point, he indicated in this sentence that at some point it may become unjustified to require states to create opportunity districts, that is, districts in which members of minority groups have an equal opportunity to elect candidates of their choice, if it requires racial, sorting, essentially, racial or race-conscious districting. And the way they have presented the case, they've said, given the findings that we've now created about what we want to do in creating this new district, there is no way to create a black opportunity district without relying heavily on race. That itself tees up the constitutional question that Justice Kavanaugh said at some point might be an appropriate question for the court to decide.
And they did not make that argument before?
They did not make that argument in last year's appeal. They are making it now, but I think it's awkwardly teed up, and the posture is not a particularly attractive one for the court to sort of reverse itself 1 year later based on this kind of obviously retrofitted set of findings that the lawyer for the party created after the fact to try to justify refusing to provide a second district.
Just to clarify one thing, I think there are sort of two slightly different arguments going on, right? One argument is the point that Kavanaugh made that maybe over time, the degree of race consciousness that Section 2 contemplates may no longer be permissible. That's one argument that they didn't make before, that they're making now. I agree with David, that's going to be awfully hard to sort of inject into the case at this point. But they do have a different argument, which I think David also referenced, but I think it's important to keep them separate, right? Which is that Section 2, it's not like the statute gives, by its terms, a right to have a certain number of minority districts in any given jurisdiction. What the statute says is that you have to give them an equal opportunity. And what that is done, the way the court analyzes that is by comparing what the plaintiffs are asking for to what the state itself did, and sort of compare whether the plaintiff's plan complies with the sort of principles that the state has, but would also give blacks more electoral districts. And so what's the change in the case, the big one, is what the court found the first time was that the plaintiff's maps were just as good as the state's maps at the state's interests, but would have a second black district. And what Alabama has now done is said, okay, fine, we're coming up with a totally different map than the last time, and now you can't say that your map is just as good as our map, because it's not as good. And David says that, they disagree with that, and the trial court agreed with them. But that's what the fight is that it's not like the statute gives plaintiffs like an automatic right to a certain number of minority districts. It's always a comparison between what the plaintiffs are arguing and what the state interests, the interest the state is asserting. And the state is basically saying they've redrawn their map in a way that has different interests.
Would the state say that the Supreme Court did not order a second majority minority district?
Yeah, so that's basically the point, right? Is that the case was up there the first time on a threshold question about liability. Under this Jingles framework, which is what the plaintiffs have to show to prove their case, had they proved the first prong of Jingles. That doesn't ipso facto mean they're entitled to a second district. They remanded for a remedy, and then basically what Alabama did is sort of pretermit that by saying, look, we're just changing our map. And David's right that like it has the sort of feel of from days of yore where when southern states lost a case, they would just change their rules. But Section 2 sort of invites that in the sense that it's a comparison, right? It's not there's a given right to a certain set of lines. It's always in comparison to what the state's interests are. And there's nothing that says states can't redraw their maps, right? Like even if nothing had happened this time, 3 years from now, Alabama certainly could have redrawn its map, and then the ACLU would have certainly had to bring a new suit. And so then it's just a question of whether they somehow can't do it right away.
I'm wondering if even you admit that this has the sort of
I love the even you.
I mean, your firm represents South Carolina.
Well,
Admit
now we're
that
talking
this
about
has the feel of the cases of yore. I wonder what any of you think about sort of the optics, even within the court, of entertaining yet another appeal from Alabama, especially in light of all the stuff about Purcell that went on the last time. Alabama conducted a 2022 election based on a map that the court has now found to be invalid, and they are on a very tight deadline.
So look, I think this ties to, I can't remember who said it earlier, right? That some litigants have been too aggressive in the court. I think the Alabama case is the sort of poster child for that, right? Like they teed up the last case in a very, very aggressive way rather than making a narrower argument along the lines of what Justice Alito would have done. And then because they were very confident about how they were going to win, they didn't, for example, say, even if we lose on the merits, that doesn't mean that the remedy is a second black district. Here's the alternative map we would draw. Like they didn't set it up in a way that the court, if the court wasn't going to agree with their frontline position, wouldn't feel like they were getting jerked around.
So,
and they've now set themselves up in a way that it's going to be portrayed as Alabama's defying the court. And I think that's partly a function of the fact that they weren't more strategic about it on the front end.
Well, and I would just add that, what they formally did was affirm the preliminary injunction. And what the preliminary injunction said was create a second majority black district or an opportunity district, which is close enough to majority that African Americans will have an equal opportunity to elect. So I do think it'll have that feel.
So the question is, do you think the court will feel that this is sort of an act of defiance, and what will happen if we get a case from Louisiana, and will it bleed over to these other cases that have the same question essentially?
Well, if they don't, they should.
I wouldn't say that, but what I would say is I'm not so sure that Justice Kavanaugh will think this is defiance, but I do think Justice Kavanaugh is going to be worried it will be perceived as defiance, and frankly, that might be all that's necessary.
And it is defiance, right? The political pressures are just so strong to try to maintain as much partisan advantage as possible that they're just, blatantly refusing to even argue that they created it. They didn't even come in and say, well, we created an opportunity district and then we'll dispute whether it's an opportunity district. They admitted we did not create what you said we had to create. And so, it's defiance.
Yeah.
I mean, what do you take to the argument? I mean, it's not necessarily a legal argument, in fact, it's the opposite of that, but that like, because of the fact that they had this 3-judge panel, because of the fact that they know how the system works, there was actually no incentive for the Alabama lawmakers to do the right thing now, because they know that a special master will take care of this.
Well, I don't know. I mean, they might have, if they had followed the injunction and provided an opportunity district, they could provide an opportunity district that, nonetheless sort of gave them as much partisan advantages as they could sort of eke out. Now, a special master will be drawing the map, not the state, and the state will have input and the plaintiffs will have input, but it might not be as advantageous to some of their interests as it otherwise might have been.
It may not just be partisan advantage too. They would have the opportunity to serve other interests that, besides partisan advantage, that might be swept away by a special master. So you would have that incentive. But I have to say about these, it now has new interests. I would be very suspicious of somebody who said, well, we used to have these other interests, but now suddenly we have new interests after they found a Section 2 liability on the old plan. I would be myself, if I were a member, a justice of the court, I would be very suspicious about whether these are genuinely state interests or just interests that they're asserting so to try to avoid the remedy that seemed to follow from what the court was saying.
Nita, just zooming out, I mean, the Justice Kavanaugh statement kind of reminded me of Justice O'Connor in the Michigan case saying someday we're not going to need a race-conscious admission. I don't think Justice Kavanaugh meant, in this case, he was talking about
like in 3 months.
maybe in a couple months. Like, it was just the notion, whether he was thinking it or everybody else, or just reading it, I don't think anyone thought, go back and make this argument. It was just a comment that these are serious issues about race and that, we'll have to think about it, but not in this very case.
So I do think that they were feeding off not just that comment, but the footnote in Justice Kavanaugh's opinion that said it's important to me that the plaintiff's map meets the state's interests, or so the district court found, just as well as the state map. And so that invited the state to try to come up with a different map where a second opportunity district or a second minority black district would not meet the state's interests as well as, and that wasn't a feature, that particular part of Justice Kavanaugh's opinion or footnote was not part of the majority decision that he joined. That is, the majority did not say it had to be just as good, it just said it had to be generally consistent. And so I could see why the state would think this is an opportunity to slice off Justice Kavanaugh.
Yeah, in fact, the majority also said, we don't have to have a beauty contest where we compare the plaintiff's map to the state's map. All Jingles requires, the law that governs here, is that you demonstrate that African Americans are sufficiently numerous and compact to create a reasonably configured district, which has been defined not as meeting every one of the state's interests, but consistent with traditional districting principles. And if you rewrote it to say meeting every one of the state's asserted interests, then you just open the door for states to do what they did here, was draw a map that denies black voters an opportunity district and then retrofit your reasons so that they justify precisely what you did, and it's not possible to shift it in any way without without doing less well on the state's interests.
How much of this is just to do with the fact that the Republicans have this razor-thin majority in the House right now, and they're desperately trying to save one district in next year's election?
That's so cynical. A lot.
And Purcell is absolutely off the table this time around because the special master.
I don't think Purcell is ever off the table, but I think there's time. The folks are going as quickly as they can, and if the special master is allowed to proceed, there's time to put a map in place in time for
The majority of the justices have been very aggressive in their use of Purcell, I would say. So I definitely think it's never off the table, yes.
And Alabama already tried to suggest that in their filing. They were like, we have to have a decision by like September 29th or whatever.
So what, you think there is a chance that this time around, the court could say, sorry, Purcell, reuse this map?
You're asking if there a chance. I think there is a chance, but I do think that part of the Purcell inquiry evaluates whether they think the district court was kind of clearly correct. And if they think the district court was clearly correct, Purcell is not going to stand in the way. And you might think there are some debatable issues, but the atmospherics here, I think, will be such that Justice Kavanaugh will think it's clearly correct in the only way that matters, which is I'm not going to give anybody a sense that it's not.
Right, and the court already used Purcell to allow the state to carry out an election with with a map that they, ultimately held was illegal. So I think they'll be reluctant to have that happen again.
But can't rule it out. So I think we've reached our 11, but if you want to stick around, we still have one more case to discuss, the Pharma bankruptcy case. So Lisa, why don't you?
Yeah, I'm trying to make it so you won't fall asleep. This is such a fun case because it's just so interesting, and it's going to be amazing to watch how the court proceeds. But this is another case that comes by way of the emergency docket with an extraordinary move by the United States to block a bankruptcy-approved settlement of the Purdue Pharma bankruptcy. The backstory is there was an opioid crisis, and the Sacklers and Pharma were accused of contributing to it by manufacturing and marketing OxyContin. The claims against Purdue and the Sacklers at one point, this is taken from the briefs, exceeded more than $40 trillion, which is a lot of money. The Sacklers, these are sort of the background facts, pulled $11 billion out of Purdue and moved that money overseas, and then Purdue filed for bankruptcy in 2019. So already those are just like so much fun to report about. The settlement, the bankruptcy thing took 4 years to litigate. And to sort of fast forward to today, the settlement is such that the Sacklers will return, maybe that's not the right word, but contribute $6 billion to a fund to support relief to creditors and victims who have formed various committees. The tricky point here is that the Sacklers still exist, and the creditors insisted, look, if the Sacklers owe us $6 billion for us to get our money out, and obviously the victims have an interest in this being funded. If the Sacklers, who are not part of the bankruptcy, are still going to be on the hook and still going to be liable for claims, the Sacklers are going to run out of money, and this whole bankruptcy settlement will fall apart. So what the bankruptcy court did, which is something that you don't like to do, but it does happen, is that the settlement forces, or at least it releases the Sacklers, who are not debtors, of liability by these sort of third-party claimants. So you have a bankruptcy. Purdue, of course, is going to be relieved of all liability, but the Sacklers themselves can no longer be sued, even though they never filed for bankruptcy. So everyone loves this settlement, except the U.S. trustee. So I think all 50 states, again, this is taken from the briefs, which some of this is from Ramon's firm, but all 50 states, 1,300 local governments have approved, school districts, tribes, victims, and creditors. But and again, there's an overwhelming practical reason. Without this release, the settlement falls apart. There's a specific finding that the settlement will not work without the releases. So unless it's confirmed, nobody gets relief. So the U.S. trustee then is really mad because, and they filed a stay and said you have to block this bankruptcy settlement from going forward. This is really unfair. The Sacklers are getting a free walk and a free ride for basically fraud claims, and had they filed bankruptcy, they would not have been able to get release because fraud is not dischargeable in bankruptcy. So this is an outrage, according to the government, and the court set the case for argument. And so just to make a long story short, why it's so interesting is I think the government has a lot of law on its side. the two provisions of the bankruptcy code, and here's where it gets a little sleepy, but basically there are two provisions, 105A and 1123B6. Yeah, basically say bankruptcy courts can do whatever they want if it's appropriate. So that's the appropriate to carry out other provisions of the code, or appropriate provisions not inconsistent. So what does that mean? So the courts are divided whether that appropriate language gives courts the statutory authority to reach non-debtors. The US government comes in and says bankruptcy is all about creditor-debtor. It is completely beyond the authority of a bankruptcy court to restructure the legal relationships between non-debtors. You just cannot do that. The more interesting part is, why is the government doing this? They have absolutely no stake financially. The US trustee has a statutory right to appear in any bankruptcy case. The US trustee actually appointed the fiduciaries or the trustees in charge of this who came up with the settlement, but the US is upset. I like it because you've got this interloper of the United States. The United States is exempt from the settlement. They can sue the Sacklers till the cows come home. There's some sort of due process interest about these poor claimants who maybe want to sue the Sacklers someday. In my view, then let them sue the Sacklers and they can say the bankruptcy settlement was invalid. But it's just got this wonderful intersection of, are we going to allow the law to sort of practical reality of, this is a settlement everyone wants for the most amount of relief for claimants, creditors, states, all these people, as opposed to maybe what the law kind of says on its face. So I cannot wait to watch this case and argument.
Anyone else on this one? Press on this one?
I'm happy to entertain bankruptcy questions as well.
Thank